At the border, pulled back into a back room and questioned for hours while their phone dies in their pocket.
Welcome back to Visa Vibes, a podcast that attempts to bring some clarity to the U.S. immigration, one episode at a time. I'm Emily Newman, managing partner of Reddy Newman Brown PC.
And I'm Stephen Brown, and thanks for joining back with us here after a small summer break. We're back at it today with a very interesting topic that's in the news quite a bit. And we're going to dive into international workers' worst nightmares, and that's getting stopped at the border, pulled back into a back room, and questioned for hours while their phone dies in their pocket with very limited communication.
Yeah, it sounds very dramatic, but it is real. And if you're on a work visa, you've probably heard about someone who kind of had a rough landing with CBP.
Yeah, and so we're going to talk about what actually happens at the port of entry, what you can do if you're put into what's called secondary inspection, what expedited removal is, that's the dreaded term that we were talking about here, and how you could try to avoid travel disasters altogether. So, Emily, let's start. What is CBP's role in all this? I've got an approved non-immigrant visa petition, or maybe it's an F1, but I've got my visa. I've got an approval if I've needed. Everything seems clean. Like, why are we worried about the port of entry?
Yeah, so you may have been approved by USCIS, you may have been approved by Department of State, but you're not yet approved until you get approved by CBP. That's Customs and Border Protection. They are the people at the airport, at the border, that control admission into the US at these ports of entry. So they don't issue the visas, they don't approve petitions. That's Department of State, that's USCIS, but they have the ultimate authority to either let you in or not. And so when you are coming to the airport, we'll just use that as an example because that's most common for our clients. The CBP officers, you go up to that window, they're going to verify your identity and they're going to verify the purpose of your travel to make sure that it's in line with the type of visa that you are attempting to come in on. Then they're going to issue you an I-94 record. We usually call it an I-94 card because it used to be a little white card that they would staple to your passport. Now it's all electronic, so you have to go to the CBP website, and that is what governs your authorized stay. They may check the details of your petition in the PIMS system. This is the Consulate's Petition Immigration Management Service to validate the petition. Department of State also has access to PIM, so it's shared between USCIS, DOS, and CBP. They might want to look at your supporting documents. They might ask for your I-797 approval notice, an employment verification letter, any other supporting documents that go along with the purpose of your trip. And they do have the right to deny entry, even though you have a valid visa. If for some reason they think you're inadmissible, if they think that you are not coming in for the purpose of the visa, or if they think you are violating the terms of the visa or have plans to.
Yeah, and really, it's one of those things we've talked about vibes-based adjudication before, but it's what's the officer feeling? And they're not as crazy. I don't think it's the consulates, but I've seen cases that are just wildly inaccurate decisions. So just kind of the takeaway here from the beginning is even though you have your visa stamped in the passport, that just kind of lets you get on the plane and apply for admission, right? So that's kind of where everything is. Doesn't mean you're guaranteed to get in.
So what usually happens when you're at the port of entry? For most people, it's routine. You present your passport, present your visa, answer a few basic questions, maybe get your fingerprints taken, maybe a photo, do your biometrics, and then you're through.
Yeah, and tens of thousands of people probably travel internationally and come to the U.S. without issue every day. But what we sometimes see is maybe there's flags in the system. Maybe it's a common name match. Maybe it's an old violation. Maybe you didn't articulate things properly to the first level officer, so you could get pulled into what's called secondary inspection. So everybody, when they come into the U.S., even U.S. citizens, they go through customs and immigration, and it's very quick, it's very brief, it's check out your passport, what are you here for, a couple questions, very quick. But if something seems a little odd for non-US citizens, that's where secondary inspection comes in. This is going to be a much more detailed scrutiny. It might be an interview, maybe I'll tell you, Emily, advanced parole, it's not atypical. It's very common for them to get put into secondary until somebody's like, no, 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 this is legitimate and let them through. It doesn't mean something's wrong, but it does mean they want to look more into it more than the 2 to 3 minutes they allocate at the window. So they're going to look at your I-797s. If you're on a student visa, your I-20 or your DS 2019, if you're on a J. They're going to look at your employment verification letters, confirming that the job offer, that you still have a job, your travel history, your visa annotations, whatever records they have in their system that we don't all know what's there. And this is the one I think nobody ever thinks about. It's obviously more common now, but they can go through your phone and your email. And it's not just, your text message. They'll hook it up to a machine. They can see what's been deleted, what's been discussed in WhatsApp, what's in your emails. So, their job is kind of that level of protection to ensure everybody is granted admission. So, um, even if you have a small inconsistency, if you work for ABC Inc. and you say I'm with BCA Inc., that could cause suspicion.
Yeah. So, with that first line, I think the officer's goal is to get people through as quickly as possible. And obviously, an entire international plane has just landed. Everybody is standing in line waiting. So, if they can't get you quickly through, they're going to set you aside and say you need to go to secondary. Doesn't necessarily mean something's wrong. As you mentioned, like advanced parole, it's pretty common. It's just because they can't process you quickly. So they send you aside for just this longer process. But it's kind of like immigration limbo when you're in secondary inspection. You're not like denied, but you're also not admitted yet either. You're just kind of waiting to see what's going to happen.
Yeah, and they'll bring you into a separate area. You don't, can't make a phone call. There's no lawyers. You just wait to be called. Sometimes it's a big waiting room before you go to the back room. I know I had a case a few years ago where one of our clients called me and said, his wife hadn't heard from him. He flew here into Houston. He said, "Do you know anything?" I was able to call and they said, "Yep, he's safe," but that's all the information they gave me. So Emily, let's talk a little bit about what happens during this secondary. I've seen them call employers, maybe the end client. Do they go through all the electronic documents too?
Oh, absolutely. Yeah. If you have your laptop with you, your cell phone with you, they will ask you for the password so they can open it up or ask you to open it up. And they do go through. They look at your emails, they look at your bank statements. They're looking for transactions to verify that you are getting the direct deposits for your payroll. They're looking at emails you're sending. They're looking at photos.
Yep.
You definitely have an interesting case.
Yeah, there was a case, maybe 3, 4 years ago, where an individual, he was on a student visa, but he was also looking to invest and purchase a grocery store or a chain of grocery stores. I can't remember exactly. And he had pictures of the back offices of the grocery store. Wasn't working, just trying to look into possibly investing. Nothing wrong with that, but CBP saw this and said, "You're working. You're clearly working based off of this," and put him into expedited removal, which we'll talk about in a little bit. So, they do look at these things, and sometimes they'll listen to the explanation, other times they're not. And so, from what I recommend to people, try to take as much mental notes as you can. You should get a transcript of your secondary inspection, although Emily, I've seen times where they don't. We've got to try to track that down. But things can go a little weird.
Yeah, I mean, it can last for maybe just 30 minutes or an hour, especially if it's the advanced parole type of secondary inspection where they're just verifying that your advanced parole is valid and your 485 is pending. But otherwise, I mean, it can be like 2 hours of grilling interview where they're trying to catch you in any kind of inconsistency, making accusations, waiting to see if you're going to break, waiting to see if you're lying in any way. So the most important thing is number one, you have to be honest because if you lie to CBP in secondary inspection, that by itself, whether the lie was right or wrong or wasn't relevant to what's going on, lying to CBP is an automatic bar, inadmissible, not really a easy way to
No.
overcome that, no waiver. So be honest, do your best to stay calm, don't panic, don't rush to say something wrong because you just want to get an answer out. We see that happen so many times that people are just so flustered that they say the wrong thing or get confused. So just stay calm, don't panic, take your time. It's okay to take a second and say, I need to think about this before you answer. You don't have to feel like you need to fill the dead air. If they ask a question, you simply answer it and wait for them to ask the next question. You don't have to keep talking because they will let you keep talking until you hang yourself by your words, whatever it is.
Yeah, and I know, we've both seen this plenty of times. I mean, I get tired just traveling to like Washington, D.C., and that's a short flight now, let alone a international flight that's 12, 14, hours. And you break down a little bit, and your mind doesn't work as well. And sometimes people just misspeak or they mishear what the question is and answer. So definitely take the time to process. And if you don't understand fully the question, ask for clarification because I have seen plenty of cases end up poorly. Simple miscommunications. Nothing wrong, but it's just a misunderstanding of the question. So, it's a pop quiz given to you by somebody who doesn't want you to pass the class.
Right. Yeah. So, if things go south, worst case scenario, typically you're looking at what we call expedited removal. So that's a fancy way of saying fast deportation. Removal is the correct term now for deportation, and expedited means fast. So this is where basically CBP decides that for some reason you're inadmissible, and so for that they are going to remove you, deport you, send you back. There is no judge, there's no appeal, there's no lawyer. It's fast.
It's not even really due process, to
Yeah.
be honest with you. And this was designed by Congress, originally more for southern border turnaways, and it's been more used at ports of entry. But look, when somebody's applying for admission or crossing the border, a quick, efficient way, right or wrong, to remove people. So it is designed to be quick. You don't, get to have a hearing, although there's arguments whether you can have a habeas while you're detained. But we see this pop up, if there's fraud, misrepresentation, if you don't have the proper documentations, sometimes somebody didn't know their visa has been canceled.
Mhm.
And
Yeah, we just had a consultation on that today.
yeah, just had no clue
Yeah.
that it was canceled, and they show up, and that is a grounds for inadmissibility. Whether they think you have immigrant intent when you're not supposed to, H and L, that's okay, but an F1, you can't have immigrant intent. But really, sometimes we think something's wrong, and we're going to turn you away. And instead of just saying no, we're going to die admission, they hit you with the expedited removal.
Yeah, and the consequences of expedited removal are quite steep. It's not simply, okay, I was denied admission, let me go back home. It is adding on top of that a 5-year bar from you being able to come back into the US. So they're typically going to cancel your visa if it's valid, and then they're going to bar you from coming back for the next 5 years, which means if you were to go back and apply for a new visa at the consulate, they have to deny it over the next 5 years. There's no way you can get a new visa unless you take the next step. It also means that you're no longer eligible for the visa waiver program. So people that travel on ESTA, that's what they typically call it, you have to now apply for a visa going forward instead of just using your passport in the ESTA system. It's going to be a permanent mark on your record in all kinds of databases: Department of State, DHS, USCIS, CBP, ICE. Everybody has access to that. And it definitely impacts future visa applications, even after 5 years,
Oh,
once you meet that.
yeah, because most of the 485 and the DS-160 ask have you ever been removed, not within the last 5 years, and so it is a 5-year bar if you're expedited removal, but if you do something like fraud or misrepresentation, that is a permanent bar. That's why Emily said don't lie. I mean, look, a 5-year bar is bad. I'm not sitting there saying that. It's a lot better than a permanent bar, that fraud or misrepresentation. So if they think that there's something wrong, this is the hammer that they use. So, Emily, what do I just have? I have a bad feeling. Like I'm at the port of entry, things kind of aren't feeling the way I think they should. I've traveled many times. This one feels different. Like what do you recommend?
Yeah, so if you're starting to feel like things are going south and you're ending up in trouble and you're in secondary inspection, a few things to remember. Number one, you do not have the right to an attorney, so you're on your own. But what you can do is actually request to withdraw your application for admission, and voluntarily depart. Go back to your home country, you pay for the flight. The benefit of that is yes, you're still not being allowed into the country, but they treat it as not a denial, and they don't treat it as an expedited removal. This means you're avoiding the removal order and you can avoid the 5-year ban. So you just go back. So they might still cancel your visa, and that just means you can apply again at the consulate. And if the consulate gives you the new visa, you can come back again. No issues. But if you get into that actual expedited removal, now we have the 5-year bar. So ask to withdraw your application for admission. Ask it to clarify what is the issue, what's the basis for the concern, because sometimes it's not clear. Sometimes they might be thinking something completely wrong, completely miscommunication happening. So try to inquire what's going on. They may not tell you. It's not a pleasant experience. They might not be happy with you, but that is your right to try to figure out what's going on. Always stay respectful. Don't try to guess what it is they're after. Like, again, as you said, clarify. If you're not understanding the question, ask for clarification. Again, don't lie. Don't volunteer too much either.
Yeah, and withdrawing your application is just it's basically saying, look, I get it. This isn't gonna work out. I'll go home, sort this out. And this is really the lesser of the evil. I know it's a huge inconvenience. It's a huge expense, and not looking down on that at all. But it's better than the 5-year bar. So after your release, my suggestion, whether it's expedited removal or you can withdraw, is contact immigration counselor as soon as you can. I think acting quick to preserve your mental state of what has happened is important. Trying to note that down, but also get on top of fixing it as quickly as you can.
So yeah, what happens after something goes wrong? Let's say it is too late. You're denied entry, expedited removal. You've left the country. Now you're like figuring out, what do I do? What are some options for?
Yeah. Yeah, so there's really two avenues you can go with expedited removal. Um, and it can sometimes be a chicken or the egg discussion on which one you do. My thought process is to do one before the other. We'll talk about that. If you get put in expedited removal, you have the 5-year ban. The only way to typically remove that 5-year ban is an I-212 waiver. This is a permission for reapplication for entry, and it's trying to get permission now to go come in again before the 5-year bar. The other thing you can do, and we've had success with this, where frankly, I think DHS improperly applied the law, didn't really apply the facts right, is called DHS TRIP. I think it's the Travelers Redress Inquiry Program. It's an abbreviation. Now, you don't have a right to appeal an expedited removal order. You can't sue over an expedited removal order. Now, that's something that maybe stay tuned, but you typically can't appeal or sue on it, but you can seek redress. I view it kind of like an appeal through here. Sometimes, you can go through and brief, like, hey, this is what happens. This is why I think it was incorrect. Can you guys take a look at it? It does take a long, long time. I mean, I just finished up one from like December of 2023, okay? It wasn't quick, but it's quicker than the 5 years, and it cured a lot of things. But the 212 waiver application for permission to reapply, you would complete that. You would go to the consulate for your interview, apply saying like, look, I had my expedited removal. I marked it on my DS-160. I need a 212 waiver. And the officer can recommend it. They don't have to. It's all discretionary. And it would go to CBP to adjudicate whether they want to grant the waiver or not.
So, what does this I-212 require? Mainly, it is a detailed statement that explains the circumstances of removal, why reentry should be granted. Maybe you have a very important job in the US, you've never committed fraud or misrepresentation, you have rehabilitated, you've seen the error in your ways, you agree to never do it again. You've got family ties in the US, you have employment in the US. So they look at kind of what are the equities here, like what are the pros for letting you come back into the US versus the cons of why we expedited removal of this person in the first place, and balance that to decide whether in their discretion they're going to waive the 5 year bar and allow you to come in. But it's definitely not automatic. And as you said, it takes a long time. So sometimes people 2 years after the expedited removal decide, you know what, I want to look into a waiver. I want to apply for this 212. And we're like, well, it's going to take you three
I
years to get it. So you might as well just wait the 3 years.
I remember having a conversation. I thought it was a very clean case for a waiver, but they didn't really know about waivers, and they were 4 years in. I said, "Look, you're probably better just waiting the year. It just isn't gonna be done." But this is something you really should look at, a tactical way of doing things. Maybe in certain cases, I'm going to argue that there shouldn't have been a grounds for inadmissibility, that things were misinterpreted or the law was misapplied. Other times it's all about, hey, here's the positives only, right? Maybe they got it right, okay? And we're just going to be, hey, let me get this permission now because of X, Y, and Z. So it really is asking for forgiveness, but again, you want to act quick because I think it also helps having the right mindset in your memory from you on what happened. I can tell you there was a case where everything was about a previous employer that the individual had no knowledge of them submitting documents that they weren't aware of. It wasn't really in the transcript, but it was asked about, and we were able to kind of make a case around that because they acted quickly.
So, other option is this DHS Traveler Redress Inquiry Program. If you think you've been unfairly flagged, or if there's some sort of miscommunication, or if they just got it all wrong at CBP. So, this is also for people who've experienced frequent secondary inspections. Maybe your name just pops up. Like I have a friend who somehow her name pops up with someone who like runs guns between the US and Canada. So every time she's coming back from Canada, she gets.
When I was 10, my younger brother was on the do not fly list, like right after the Patriot Act and everything. So sometimes there's name confusion.
Yeah. Yeah, so you might end up on a watch list unnecessarily. But if you just constantly have delays or questioning with no clear cause, or trouble boarding a flight that you shouldn't have any trouble with. So these are all reasons to use the DHS trip in addition to trying to correct something that went wrong during an expedited removal.
Yeah, and DHS trip isn't just for removal. I mean, like Emily said, if you constantly have issues, you shouldn't have to go through secondary every time. But we've seen people, like, for whatever reason, they're always there. But this is done online. There is no filing fee for it. It's dhs.gov/DHS-trip. There isn't any formality to it. I can tell you as attorneys, I put more formality to it for the brief, but individual, there isn't a form you use. It's all done online. It's not, oh, I download this and I send it to this lockbox or whatever, like you do with USCIS. But, make that strong case about why this was improper.
Yeah, so, and again, this also takes months.
Mm-hmm.
You're going to get a redress control number and you can keep checking on it. And then when you do get the result, sometimes it's a letter. Well, it's always a letter, but sometimes it's not quite clear what they did. They'll just say, we have updated your record. And
Yep.
Then you've got to figure out, okay, what did they update? Did they update things in our favor to where now I can apply for a visa or not? So it's a big guessing game.
My last client that we did this is we did the DHS trip, very strong case, and then it said we've updated our records. I think they changed the inadmissibility reason, so it's like, okay, we've kind of got to take an educated guess on this, and applied for a visa again, and got it. And so we're like, okay, they updated the way, records in a good way. But they don't sit there and say, "Oh, we've reviewed it, and because you said this, this, and this, we're changing our decision."
All right, so recap, I-212 is if you've actually been removed, have that expedited removal, and need the visa again when you're still within the 5-year bar. DHS trip is if something's been flagged, if just something went in, like, so the 212 is when they were right
Mm-hmm.
to remove you under expedited removal. You don't have any argument that they were wrong, so you're just asking forgiveness. Let me try again. The DHS trip is when CBP got it wrong and shouldn't have ever removed you in the first place, and then you can go through that process.
Yeah, so let's try to avoid this, right? Most people do, and this is what I tell everybody. As lawyers, I want people to kind of know what the worst case scenario is, and we get called fear mongers, and that's okay because I'd rather give what the risks are and let people make their decision. But frankly, like I said, tens of thousands, if not hundreds of thousands, of people travel internationally every day without issue. Obviously, I get more concerned when there's a 5-year bar. So let's talk about some of the things to avoid this. So review all your documentation. I think that's the key. Like what has been said in your TS-160 in your petition, for you to, so you can make that discussion if you need to. Keep a physical and digital file, of your passport, your visa, your status documents, your offer letter, pay statements, whatever was in the petition. Know what you're doing. Sometimes people just misspeak and they say oh yeah, I work for the end client if they're on a project, or like I said, sometimes it can be as innocuous as it's been 6 hours and they say their old employer instead of the current one. Make sure you have updated addresses. If you're coming in to Chicago and your license says you live in Houston, they might look at you a little strange.
Yeah, and make sure an amendment's been filed if you're on H-1B and you have worked in a different location. You also, we would say, probably not a good idea to travel while you've got a pending application, especially an amendment. You want to get that approved first. Um, be careful about intent, non-immigrant intent. So anyone who's coming into the U.S., anyone who's applying for the visa, you're always guilty until proven innocent when
Yep.
it comes to intent. You are always an intending immigrant, and it's your job to prove otherwise. And that becomes very important for any visa applicant coming into the US, except for H-1B and L1, L2, H4. Those allow dual intent, but the other ones don't. So if you're coming in on a B visa, you need to make sure that you're aware of the B visa requirements and that your goal is to be coming temporarily, you have a residence abroad that you plan to return to, and that you will leave at the end of your stay. And then watch what you post online as well.
That's big now.
Especially now, we know, for several years in the DS-160, you have to put in your social media information, but now they are reviewing it and vetting it before they're even issuing the visa. Especially that's the plan with F1 student visas. They've stopped all interviews right now so that they can come up with their new method of vetting students. And then once they start interviewing, they're going to be vetting their social media. But for employment based work visas, we would say watch your LinkedIn, make sure it's updated, make sure it has your correct job title, make sure it has your correct employer, because they do have access to that. It's all public information.
Yeah, we've seen that for years. I mean, I know the administration right now is talking about social media, but I mean, we've seen that for at least a decade of somebody has an issue with LinkedIn because they haven't updated it, or they put, if they're consulting, they put the end client as their employer. So just be smart about it. On our firm's YouTube, we talk about automatic revalidation, or the margarita visa, quite a bit. Make sure if you're doing that, you're only doing it when you should and if you're eligible. I think you have to be strategic, especially in the times things are now, about planning and making sure you're doing things 100% right, because they're not going to give you the benefit of the doubt.
Yeah, so you definitely don't want to show up to a final exam unprepared. So don't do it with CBP either. You want to review your petition, review your LCA if you're on an H-1B. And if anything in your package that was prepared, your petition that was filed, if it's not accurate, you need to talk to an attorney and make sure it gets corrected before you try to enter in. You don't want to come in and continue the inaccuracy. For sure. If you also don't want to create a discrepancy, if the petition says one thing, but in actuality it's something else, and you're honestly giving the correct information, now there's a discrepancy with the petition. So all that to say, be prepared, know what the issues are, so that you can avoid expedited removal, because it is avoidable in many cases.
Yeah, I mean, like I've said throughout this episode, more people have success with travel than issues with travel. But, I think anytime anybody has these issues with travel, it gets blown up on social media or Reddit or Telegram, WhatsApp, whatever. So I know this is kind of a stressful episode, especially, we're here in the summer and people are planning travel, but we're trying to get you prepared on being prepared to avoid the issues, and if you have those problems, what you can do from there, that not all hope is lost.
Yeah, prevention is definitely the best remedy here. But if you have faced any of these issues, don't just sit on it. Talk to a lawyer. See if you can do a trip request. See if a waiver 212 is possible. Fix it before it turns into a bigger problem down the road and while your memory is still fresh.
Yeah.
Thanks for joining.
Thank you.